The top at 6, we begin with a stunning development in the double murder trial of YNW Melly.
After days of deliberations, the jury was deadlocked, leading the judge to declare a mistrial. And Local 10's Joseph Ojo was at the courthouse in Fort Lauderdale with reaction. And what happens next?
YNW Melly ended up in deep trouble, the kind you can't just walk away from. Alongside his co-defendant, YNW Bortlen, he had been battling a heavy double homicide charge for 4 long years, accused of killing 2 of his own closest friends. At first, the two moved together like brothers, locked in step, showing a united front and backing each other through the long grind of the first trial. But the bond cracked when Bortlen decided he'd had enough and went for a plea deal. In court that day, cameras captured every moment, and what came out raised even more questions about Melly's fate and what the future could bring.
And decisions ending after 3 days, with the jury not able to come up with a unanimous decision to decide the fate of YNW Melly.
I'm going to just declare a mistrial.
After considering all the facts, jurors in YNW Melly's double murder trial unable to come up with a unanimous decision Saturday. On Friday, they asked for cell phone records and told the judge they were deadlocked. Melly's defense team thanking the jury for their efforts throughout the trial, but adding they were expecting a different result.
We are somewhat disappointed that Melly is not walking out the door with us.
Melly, whose real name is Jamel Demmons, is accused of murdering Christopher Thomas Jr. and Anthony Williams in October of 2018. Surveillance video shows the group leaving a Fort Lauderdale recording studio that night, and prosecutors say Melly shot and killed Williams and Thomas soon after.
Jamel Demmons was sitting in the back seat of that Jeep, and he was the one that fired the fatal shots that killed Christopher Thomas and Anthony Williams.
Investigators believe Melly and another friend then drove the car to a secluded part of Miramar, where they are said to have staged a drive-by shooting to use as a cover story. But Melly's defense team has maintained there are major holes in the state's case, even bringing their own witness who said Melly learned about the murders at the same time as the rest of their friend group.
There's a lack of evidence, there is a conflict in the evidence, and the evidence itself and the investigation itself stinks.
And the jury did have a chance to decide on a lesser charge. This case will be retrialed, so we will keep you updated. We're here in Fort Lauderdale. I'm Joseph Ojo.
That first trial had already ended in a hung jury, a razor-close mistrial that barely saved Melly. Out of 12 jurors, 11 wanted to convict him, while just 1 held out. And that lone juror wasn't steady. Reports described him as erratic and unpredictable, which left the whole case dangling on shaky ground. Still, conviction wasn't automatic. The missing murder weapon created a huge hole for prosecutors, blocking them from presenting solid physical evidence. On top of that, the ballistic evidence sparked debates. Some experts swore Melly had to be the shooter, while others argued it would have been almost impossible from his seat without twisting the weapon at strange angles. That confusion cracked the case wide open, leaving real doubt for jurors to chew on. Then came the biggest issue of all, motive. Prosecutors were asking 12 strangers to believe that Melly killed 2 men he loved enough to tattoo on his body, 2 men the world knew as his best friends. Without a believable motive, convincing a jury became a mountain to climb. The defense pounced on that weakness. They hammered home that Melly had no reason to turn on Sackchaser and Juvie. In opening statements, the prosecutor tried to cut through by saying motive wasn't required. All that mattered was proof beyond a reasonable doubt. But that missing motive left a shadow of uncertainty, one the defense used to punch holes in the case and keep doubt alive. Prosecutors painted a picture of rising tension between Sackchaser and Melly, a clash over power and control that could have boiled over at any moment. Reports claimed Sackchaser had the rights to the YNW brand and trademark, while Melly was itching to break free from that grip. When talk of a big deal surfaced, arguments reportedly flared over how the money should be cut, with Melly pushing hard for a bigger piece of the pie. There were even wild accounts of a fight where Sackchaser allegedly knocked out Melly's grills right in front of his girlfriend. That kind of humiliation would have stung, no doubt. But even if that story was true, it only spoke on the beef between Melly and Sackchaser. It didn't explain why Juvie ended up in the line of fire. Some whispered that Juvie might have been silent simply because he saw too much. Still, so much of this was guesswork. Without a locked-in motive or a full breakdown of what really went down inside that vehicle, prosecutors were stuck chasing shadows. At the end of the day, only two people truly knew what happened that night: YNW Melly and YNW Bortlen. And that's why Bortlen's plea deal flipped the whole situation upside down. The burning question became, did his deal force him to spill everything he knew? Because if Bortlen dropped details only he and Melly could confirm, that could hand prosecutors the missing puzzle piece they needed to nail Melly for good. At first, Bortlen was given the deal with just a short time to make his move. But when the window was extended, within 5 days, he showed up in court, ready to reveal his decision. And everyone leaned in, waiting to hear what came next.
Swear to tell the truth, whole truth, nothing but the truth? Okay. You can put your hand down. Please state your full name. How old are you? How far did you go in school? Right. Do you read and understand the English language? Are you presently under the influence of any drugs, medication, or alcohol? Have you ever been treated for a mental illness? Are they giving you any medication in the jail right now? How are you feeling this afternoon? Your head is clear? You understand what's going on this afternoon? You understand you're resolving 2 pending felony cases this afternoon? Right. Mr. Haddad or Mr. Nascimento, have you seen or heard Mr. Henry say or do anything which would call into question in your mind whether you understand what's going on?
Nothing at all. No, you're not.
All right, so Mr. Henry, it's 2 cases, sir. I'm going to go one at a time. In case number 19-1871 CF10A, this is before the agreement you made with the state, before the deal you made with the state. You were charged as follows. Counts 1 and 2 is murder in the first degree with a firearm. Those are capital offenses. The maximum and mandatory penalty is life in Florida State Prison. Counts 3 and 4 are accessory after the fact to murder in the first degree. Those are each first degree felonies. The maximum penalty is 30 years in Florida State Prison. In case number 23-10643 CF10A, you're charged at count 1, tampering with a witness in a capital felony. That is punishable by life in Florida State Prison. Count 2, directing the activities of a criminal gang. That's a first degree felony. Again, punishable up to life in Florida State Prison. Count 5 is conspiracy to commit tampering. Again, as it relates to a first degree murder charge, that is punishable by a maximum penalty of life in Florida State Prison. And count 7, unlawful use of a two-way communication device. As charged, that's a second degree felony. The maximum penalty is 15 years in Florida State.
The courtroom laid it all out in black and white. YNW Bortlen was staring down some of the harshest punishment possible. The judge spelled it out clear. 3 separate life sentences stacked on top of each other, plus another 75 years added on. It sounded like the kind of time where a man would never see daylight again. But by the end of that hearing, the whole scene flipped upside down. Instead of being locked away for life, Bortlen struck a plea deal that changed everything. He pleaded no contest, and suddenly his fate dropped to just 10 years. And since he had already done 4 years behind bars, that meant he'd only have about 6 left to serve before touching freedom again. That's a massive turnaround from never leaving prison to planning for a release date. The shift left people stunned, wondering how a sentence that heavy could shrink so fast. 3 life sentences plus 75 years, down to 10, that's not just unusual, that's almost unheard of. Deals like that don't come cheap, and they almost never come without hidden conditions, which left everyone in that courtroom and beyond asking the same thing. What exactly did Bortlen have to give up to secure a deal that sweet?
So, sir, again, before the agreement you made with the state, before the deal you made with the state, your maximum exposure here was life in Florida State Prison, followed by 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 75 years in Florida State Prison. Sir, do you understand all the pending charges and the maximum possible penalties involved? And it's my understanding that you want to resolve both cases today. Is that correct?
Yes, sir.
And that resolution is an agreement you've reached with the state, the terms of which are as follows. Number 1, in the 19 case, you're going to plead no contest to both counts of accessory after the fact. In the 23 case, you're going to plead no contest to all 4 counts as charged. In exchange for that, the state is going to null process, that is, drop the 2 first-degree murder counts. All right, I'm going to adjudicate you guilty. Yes, sir. What's happening with that?
That would be no problem.
So he's only going to plead to the tampering with a witness in a capital felony, conspiracy to commit tampering, and unlawful use of a two-way communication device?
Just the tampering and the unlawful use.
Just count 1 and count 7.
Correct.
State you're going to null process count 2 and count 5.
Correct, Your Honor.
As it relates only to Mr. Henry.
Correct.
Okay. So Mr. Henry, what it's going to be is 2 counts of accessory after the fact, tampering with a witness in a capital felony, and unlawful use of a two-way communication device. In exchange for that, I'm going to adjudicate you guilty on the 2 accessory counts as well as the tampering count. I'm going to sentence you to 10 years in Florida State Prison. That will be followed by 6 years of reporting probation. In the unlawful use of a two-way communication device, that's a second-degree felony. The maximum exposure.
It's a third degree, Your Honor.
It's the second as charged, I believe. It's a third, except as it relates to a capital case. But I'm happy to look it up.
That'll be discussed.
So what did you want the negotiated sentence to be for that?
That was just going to be the maximum.
5 years? Is that what you want me to do?
Correct, Your Honor.
Okay. All right, so, sir, as to that count, it's going to be an adjudication in 5 years in Florida State Prison. So the 2 accessory counts as well as the tampering count, those come with 6 years of reporting probation after the Department of Corrections sentence. I'll give you credit for all the time that you've served in both cases. All of those counts will run concurrently. All those sentences will run concurrently. All counts in all cases, that is at the same time with each other. I'm going to have to impose mandatory court costs. I'm going to order restitution payable to Terry Bagley and payable to Ashley Phillips and reservists to the amount. I'm going to give the state 120 days to tell me the amount of that restitution. If they fail to do so within 120 days, there will be no restitution. If they come back with an amount and the attorneys agree on the amount, I will impose that as another condition of your sentence to pay back that restitution. If they come back with an amount and the attorneys do not agree on the amount, I will conduct a restitution hearing. Sir, lastly, and I want to make it very clear on the record, and is unrelated to this negotiated change of plea, I guess at some point after the fact, the state wants to take a proffer from you or have a discussion with you, ask you some questions about whatever that may be. What I want you to understand, sir, is I guess that's part of this negotiated resolution, but your answers to any of those questions, whatever they might be, have no bearing on me and have no bearing on this negotiated resolution. In other words, the deal you've negotiated is the deal you've negotiated, and that's the ballgame. Do you understand all that, sir?
Yes, sir.
Have you had enough time to talk to your lawyers about all that?
Yes, sir.
They've answered all your questions?
Yes, sir.
You're sure that that's what you want to do?
Yes, sir.
Because I want to emphasize, Mr. Henry, and I'm going to do.
Even the judge couldn't hide his surprise in court, saying out loud, "I don't know how you pulled this off. How did you and your team of attorneys manage this?" That reaction made it clear this wasn't just mercy from the system, this was a straight-up exchange. As part of the plea deal, Bortlen had to agree to a proffer session. Within a week, he'd be sitting across from prosecutors, laying out what he really knew. The court made it clear this proffer wouldn't change his sentence. He had already entered his plea and 10 years was locked in. But it was the classic favor for a favor. Prosecutors needed what they couldn't nail down for years. They wanted answers that had been haunting the case. The true motive and the missing details of what really unfolded in that car the night Sack Chaser and Juvie died. This meeting had the power to tie up years of loose ends. Prosecutors' biggest questions, why Melly would even think about turning on his own people, and what exact spark lit the fuse inside that vehicle, could finally find answers. And the catch, the proffer deal would be sealed. That meant Bortlen didn't have to testify in open court. His words could stay behind closed doors, serving as a map for investigators, guiding them toward fresh witnesses, hidden evidence, or new records that filled in the blanks. In other words, Bortlen didn't need to solve the whole case himself. He just had to drop the missing puzzle pieces. Prosecutors could build the rest around his inside knowledge. Speculation started running wild about what kind of information he might hand over. One rumor floating heavy was that the motive could have been personal. Whispers that Melly was secretly involved with Sack Chaser's girlfriend. If investigators took that lead, they could haul her in, subpoena her phone, and possibly pull out digital receipts proving the story. That kind of bombshell could change everything. Another theory circled back to the music business, and the stakes were sky high. Reports claimed a record label had put a multi-million-dollar deal on the table for Melly, but there was a roadblock: Sack Chaser. He was said to control the rights to the YNW brand, and that control could have blocked Melly's shot at the money. If Bortlen confirmed this theory, prosecutors could chase down contracts and paper trails, turning whispers of money disputes into a full-blown financial motive. The wild part was that Bortlen didn't even have to testify in open court to make it happen. Thanks to the sealed proffer deal, all he had to do was quietly guide investigators, pointing them in the right direction behind closed doors. That way, he never had to publicly turn on Melly, yet his information could still reshape the entire case. Some even compared this setup to other famous cases where sealed proffers were supposed to stay hidden but later leaked, shaking up everything. As the proffer date closed in, the tension cranked all the way up. Prosecutors pushed for extra safety measures, even asking the court to move Bortlen for protection. In their filings, they stressed the urgency. This deposition needed to happen fast before any risks or outside threats could interfere with the sensitive info he was expected to reveal. For Melly, the danger couldn't be more real. If prosecutors finally grabbed the motive and details they'd been missing for years, the case against him could lock into place with no room left for doubt. Bortlen's knowledge was the missing key, and once he handed it over, the door to conviction might slam shut on Melly for good. So what do you think? Was this deal the final play prosecutors needed to seal Melly's fate? Drop your thoughts in the comments. Don't forget to like, subscribe, and share, and I'll catch you on the next one.